Section 21-5, Certificate of Historic Appropriateness. A. Purpose. In order to ensure the preservation of the historic character of historic properties and historic districts, a certificate of historic appropriateness must be obtained prior to the issuance of any zoning permits or approvals as described below, pursuant to the standards set forth in this section, except where exempt pursuant to the provisions of this section. B. Applicability. 1. The requirements of this section shall apply to applications for the permits described herein that are submitted after August 21st, 2018. 2. Certificates of historic appropriateness may be issued by the Commission or the Historic Preservation Officer pursuant to this section. 3. Certificates of historic appropriateness issued by the Commission. Review and determination of certificates of historic appropriateness by the Commission pursuant to the requirements and processes of this section and as determined by the Historic Preservation Officer is required prior to the following. A. Site plan review and limited site plan review approvals for historic properties and properties within historic districts, with the exception of short-term rental zoning permit applications. B. Site plan review approvals for properties located within 300 feet of a historic property or historic district, except that certificates of historic appropriateness are not required for limited site plan review applications pursuant to Article 3.7 Site Plan Review of the Charleston County Zoning and Land Development Regulations Ordinance, and short-term rental zoning permit applications for properties within 300 feet of a historic property or historic district. C. The issuance of zoning permits on a historic property or a property located in a historic district, including construction of new structures in historic districts. The following specific types of zoning permit applications are exempt from the Certificate of Historic Appropriateness requirements of this ordinance. 1. The proposed work is part of a project undertaken by Charleston County Public Works, and the subject properties do not contain identified contributing resources. 2. Historic markers/signs. 3. Existing communications towers where no changes to the lease area or equipment area are proposed. 4. Face changes for existing legally permitted signs. 5. Home occupations. 6. Permits for tree removal that meet the requirements of the Charleston County Zoning and Land Development Regulations Ordinance. 7. Use changes that do not require site plan review approval. 8. Sweetgrass basket stands. 9. Short-term rentals. 10. Power poles where no alteration, modification, addition to, new construction, rehabilitation, relocation, or restoration is proposed. 11. Temporary special events. 12. Temporary uses and structures. And 13. Proposed work that does not include changes to the architecture, site layout, or building size/configuration, and that is not located on a property containing a contributing resource as determined by the Historic Preservation Officer. D. The issuance of zoning permits for the demolition of structures on historic properties or on properties located in a historic district when the structure proposed for demolition has been noted as a contributing resource on the National Register of Historic Places listing or by the County Council. E. The issuance of any zoning permits for 1. Clearing and grubbing of 1 acre or more on historic properties or on properties located in a historic district, and 2. For clearing and grubbing on historic properties or on properties located in a historic district where there is a contributing resource on the subject property or an adjacent property. The clearing and grubbing application must illustrate the proposed development for which the clearing and grubbing is requested. A certificate of historic appropriateness is not required for clearing and grubbing applications associated with an approved development plan or violation. Five, certificates of historic appropriateness issued by the Historic Preservation Officer. A, review and determination of certificates of historic appropriateness by the Historic Preservation Officer pursuant to the requirements and processes of this section is required prior to the following. 1. Any exterior repairs that do not involve changing the appearance of the structure. And 2. Utilities and mechanical units, including but not limited to applications for location of radio and television receiving antennas or dishes, supply boxes, service meters, and HVAC equipment, along with any necessary screening. B, the Historic Preservation Officer may require review and determination from the Commission for any of the application types listed above. C, the Historic Preservation Officer shall provide the applicant and property owner with written notice of the decision. D, notice pursuant to Section 21-7 is not required for certificates of historic appropriateness approved by the Historic Preservation Officer. E, any person with a substantial interest in the decision of the Historic Preservation Officer may appeal the decision to the Commission. Applications for such appeals shall be submitted to the Zoning and Planning Department Director on forms available in the Zoning and Planning Department. Appeals of such decisions shall be filed within 30 calendar days after date the Certificate of Historic Appropriateness is approved. 6. Ordinary maintenance. Nothing in this ordinance shall be construed to prevent the ordinary maintenance of any exterior architectural feature of structures designated as historic when that maintenance does not involve a change in design, material, or external appearance. 7. Emergency permits. If the Zoning and Planning Department Director has declared an emergency condition and granted a temporary administrative permit due to a use, structure, or building being damaged or destroyed by fire, flood, wind, or other act of God, such temporary administrative permits are exempt from the requirements of this ordinance. 8. Interiors. Certificates of historic appropriateness shall not be required for alterations to the interior of structures. C. Pre-application conference. Before submitting an application for a certificate of historic appropriateness, the property owner or applicant shall confer with the Historic Preservation Officer to discuss the proposal and the applicable review and approval procedures. D. Application filing. 1. Application requirements. Applications for certificates of historic appropriateness shall be submitted to the Historic Preservation Officer on forms provided by Charleston County. Applications shall comply with Section 21-2.e, application completeness and submission deadlines of this ordinance. No application for a certificate of historic appropriateness shall be accepted as complete unless it includes the required fee and the following information. A. Completed certificate of historic appropriateness application. B. As applicable, a copy of a legible, approved, and recorded plat showing current property boundaries. Exemptions include applications for certificates of historic appropriateness that do not change the footprint of existing structures. C. Restrictive covenants affidavits signed by the applicant or current property owner in compliance with state law. D. Posted notice affidavits signed by the applicant or current property owners. E. A letter of intent addressing how the application complies with each of the approval criteria in Section 21-5.I individually. The letter must include a complete description of the proposed design, including but not limited to proposed building size, number of stories, architectural style, percentage of impervious surface coverage, and material choice as applicable. The letter of intent shall also indicate if there are any contributing resources on the subject property. F. A site plan drawn to an engineer's scale as applicable. If the property was developed before April 21st, 1999, no site improvements have been made since April 21st, 1999, and the proposed use does not require site improvements, as determined by the Zoning and Planning Department Director, the applicant may submit an aerial photograph printed to engineer's scale showing the property lines, locations of existing structures and improvements, parking areas, etc., as the site plan. If a site plan is required, it shall include the following as applicable. 1. Property dimensions. 2. Dimensions and locations of existing and proposed structures and improvements. 3. Impervious surface coverage and building coverage percentages as applicable. 4. Parking areas. 5. Grand trees. And 6. Wetlands. Properties containing DHEC OCRM critical line areas must contain an up-to-date DHEC OCRM signature on the site plan or plat, and holding basins and buffers when applicable. All site plans must be in an approvable state per the Zoning and Planning Department Director at the time of Certificate of Historic Appropriateness application submittal. G, architectural elevations, and H, any further information or documentation as the Historic Preservation Officer may deem necessary or appropriate to conduct a full and proper consideration and disposition of the application. 2. Board of Zoning Appeals. When decisions from both the Board of Zoning Appeals and the Historic Preservation Commission are required, the Board of Zoning Appeals decision must occur prior to the Historic Preservation Commission decision. E. Community Workshop. After the pre-application conference, it is recommended that the applicant hold one or more community workshops. The purpose of a community workshop is to 1. Ensure early citizen participation in an informal forum in conjunction with the development applications, and 2. Provide an applicant the opportunity to understand and try to mitigate any impacts an application may have on an affected community. A community workshop is not intended to produce complete consensus on all applications, but to encourage applicants to be good neighbors. It shall be the responsibility of the applicant to provide neighbor, community interest, parties and interests notice of the community workshop in accordance with Section 21-7 of this ordinance. F. Conceptual Plan Workshop. Prior to submitting a formal application, Certificate of Historic Appropriateness applicants may present their conceptual plans to the Commission at a workshop. This presentation shall be for discussion and feedback purposes only, and no action shall be taken on the conceptual plan at the workshop. The applicant shall submit a memo and presentation describing the proposed plan no later than 12 p.m. on the Friday 6 weeks prior to the regularly scheduled Commission meeting. G. Historic Preservation Officer Review and Report. The Historic Preservation Officer shall review each application for a Certificate of Historic Appropriateness pursuant to the approval criteria of Section 21-5.I approval criteria of this ordinance. The Historic Preservation Officer shall provide a report on the application to the Commission that addresses the approval criteria of Section 21-5.I approval criteria of this ordinance and includes, but is not limited to, whether or not the application complies with the requirements contained in the Charleston County Zoning and Land Development Regulations Ordinance. H. Historic Preservation Commission Public Hearing, Review, and Determination. 1. Commission Review and Determination. The Commission shall review the Certificate of Historic Appropriateness application at a public hearing and shall approve with conditions, or deny the application based on the approval criteria of Section 21-5.I approval criteria of this ordinance. When rendering its decision, the Commission shall cite how each of the specific approval criteria of Section 21-5.I approval criteria of this ordinance have or have not been met. A majority of the Historic Preservation Commission members present and voting shall be required to approve with conditions, or deny applications for certificates of historic appropriateness. 2. Notice, newspaper, posted, community interest, neighbor, and parties and interest notice of the Commission meeting shall be provided in accordance with the requirements of Section 21-7 notices of this ordinance. 3. Commission consideration. In granting a Certificate of Historic Appropriateness, the Commission shall seek to avoid negative impacts to the historic property or historic district in the context of the designation ordinance for the applicable historic property or historic district, or as included in the NRHP listing. A. When considering applications for Certificates of Historic Appropriateness, the Commission shall not 1. Make determinations regarding land uses, including whether a property can be developed. 2. Make determinations on or review subdivision plat applications. Or 3. Regulate density, intensity, and dimensional standards and other matters addressed in the Zoning and Land Development Regulations Ordinance, except dimensional standards such as setbacks, which can be affected secondarily to address design-related decisions in the context of the property's historic setting. B. The Commission shall consider, among other things, the general design, the character and appropriateness of design, the height, scale, and mass of the structure, the arrangement, texture, materials, and color of the structure in question, and the relation of such aspects, features, and elements to similar aspects, features, and elements of structures in its historic setting. The Commission may require the use of architectural techniques such as building facade and mass modulations or adjustments to the footprint of a structure on a site to achieve appropriate form and proportion of a structure in relation to its setting, so long as such techniques do not unreasonably restrict the use of a site in light of its current zoning. C, for properties and districts listed on the NRHP, the Commission shall consider the areas of significance and contributing resources outlined in the NRHP nomination listing. D, for properties and districts on the Charleston County list of historic properties and historic districts, the Commission shall consider the criteria under which the County Council approved the designation application and identified contributing resources. E, when considering applications for preservation, rehabilitation, restoration, or reconstruction, the Commission shall consider the Secretary of the Interior standards for the treatment of historic properties as contained in Section 21-8 of this ordinance. And F, if the application involves a request for demolition, the Commission shall consider the following. 1, whether the historic structure is of such architectural or historic significance that demolition would be contrary to the purpose of this ordinance. 2, whether a structure within a historic district contributes to the distinctive historic character of the district and the probable visual impact of its removal. 3, the extent to which the structure is of such unusual or uncommon design, texture, or materials that it could not be reproduced or be reproduced only with great difficulty and/or expense. 4, consideration shall be given to economic hardship or to deprivation of reasonable use of the property. 5, whether the demolition is necessary to facilitate a defined public purpose. 6, whether the request is a result of demolition by neglect. And 7, the structural soundness and integrity of the structure and the feasibility for its restoration or rehabilitation so as to allow for its reasonable use. I, approval criteria. In order for a certificate of historic appropriateness to be approved, all of the following approval criteria must be met. A, the proposed site improvements are compatible with the historic, cultural, and architectural character of the applicable historic property or historic district based on the NRHP listing or designation by the County Council. B, the proposed site improvements do not decrease the historic integrity of properties containing identified contributing resources. And C, any negative impacts to the applicable historic property or historic district have been minimized and mitigated. J, notice of decision. Following final action by the Commission, the Historic Preservation Officer shall provide the applicant and property owner with written notice of the decision. K, submission of a new application. If the Commission denies an application for a certificate of historic appropriateness, a new application affecting the same historic property may be submitted if the Historic Preservation Officer determines there has been some substantive change made in the plans for the proposed work or development in response to the decision of the Historic Preservation Officer or Commission as applicable. L, appeals. Any person with a substantial interest in a decision of the Commission or any officer, board, or bureau of the county may appeal a final decision of the Commission to the Circuit Court of Charleston County. Appellants shall file with the court clerk a written petition plainly and fully setting forth how such decision is contrary to law. Such appeal shall be filed within 30 calendar days after the date of the meeting at which the decision of the Commission is rendered. M, modifications to approved certificates of historic appropriateness. Modifications of approved certificates of historic appropriateness are characterized as major or minor depending on the type and extent of proposed changes. Substantive alterations to approved certificates of historic appropriateness, as determined by the Zoning and Planning Department Director, are considered major modifications and require a new certificate of historic appropriateness in accordance with the requirements and procedures specified in this article. Minor amendments are those that do not meet the threshold of major modifications as determined by the Zoning and Planning Department Director. The Historic Preservation Officer is authorized to approve minor modifications to an approved certificate of historic appropriateness.